I'm Michelle Benson and I'm a Mackenzie friend, and today I am interviewing Philip Kedge, the director of the Mackenzie Friend UK network and the founder of the national campaign #LikeNotHate. I'm going to put questions to Phil about his latest vlog called Why the Family Court is So Terrifying, the Blueprint of Hate. Phil, you say this is the most important vlog you have published so far. Why is that?
Hi Michelle. Firstly, thank you for that excellent introduction. And yes, I do believe that this is perhaps the most important vlog that I've done over the last 2 years. I also think it's one of the most important vlogs that any person, particularly the non-resident parent, who are mostly fathers, can see or should see before starting an application to enter into the family court system. You see, for years people have been trying to challenge the family courts by having placards outside of the family courts, going on marches, trying to highlight their own cases, and even dressing up as superheroes and hanging off government buildings. But those sort of tactics, in my mind, don't achieve anything at all. It's a bit like throwing pebbles at a tank. Now, what I want to do is to actually expose the family court in a way that has never been done before, which is exposing it from the inside, actually getting inside the tank and changing its direction. And that is what my vlog aims to do. It is to actually break down every part of every relevant part of the family court system, and to show how terrifying it is in the way that it can be manipulated by any person to, in effect, throw the non-resident parent under the family court bus, to deny or restrict contact for months and months on end, and how the family court itself can be used as a weapon against fathers. And that's why I think exposing it in this way, in a way that has never been done before, makes it one of the most important vlogs out there for people to watch.
So can you tell us what inspired you to come up with the concept of the Blueprint of Hate?
Yeah, the idea of the Blueprint of Hate, that sort of just came to me. And I think it fits really well, because what I'm trying to express when I use the term the family court Blueprint of Hate, and why that is so terrifying, is that anyone can take this blueprint and put it on top of the family court process in such a way that any person can manipulate the family courts into reducing or denying contact, as I said, with the non-resident parent, who are mostly fathers. Now, if there's a blueprint that can manipulate the family court in such a way, what I think is really important is that people understand that. We need to expose how the system is manipulated, because it's only when people understand what's happening to them can we start challenging the system from the inside. And again, this concept of a blueprint has never been put out there before. But I think when people actually listen to it in the terms that I'm trying to express and get them to understand, that they will suddenly understand it. You'll have thousands, if not tens of thousands of people suddenly saying, that is what's happening to me. And actually what is happening to me is totally unacceptable. So by framing it in the word of a blueprint of hate, because that's what it is, it's about hate, I think people for the first time ever can actually understand what's happening to them and the fundamental flaws of the family court system that allows it to be manipulated in this way.
You talk about many of the allegations in the family court being spurious and based on hate. So what you mean by spurious allegations of hate are those that are based on simply dragging up every unfortunate, potentially unacceptable, but perhaps understandable family incidents over the duration of a relationship and throwing them at your ex in hope that some of it sticks.
Yes, absolutely. I want to make it crystal clear that I'm not talking about what everyone reasonably understands about the real domestic abuse and coercive control that can happen within relationships. That's abhorrent and needs to be challenged and stopped. And of course, children and spouses protected. What I'm talking about are the ups and downs that people may experience within any relationship up and down the country. Yes, the totally unfortunate and regrettable incidences, which I'm not condoning, but on the face of it, have little or no relevance in child arrangements moving forward. But what unfortunately is happening is that parents, often now the resident parent, are taking these unfortunate incidences, which can be perhaps expected and unfortunate throughout a relationship, and then twisting them into abuse and coercive control in order to manipulate the family courts to deny or restrict contact with the other parent. And what I see all too often is the motivation of that being through hate, revenge, hurt feelings, irrational anxieties, and unfettered emotions. These human behaviours which cause people to, quite frankly, the fine line between love and hate, where the children are getting weaponised in the middle of the conflict.
So when I watch your vlog, you break it down into a number of chapters, and each chapter you explain how the family court system can be totally manipulated by the resident parent to reduce or deny child contact.
Yes, that's right. In the vlog, I actually try and break down the family court process into bite-sized chunks and then present them in the vlogs under a number of chapters. And in each of these main chapters, you can actually see, or I try and explain, how the resident parent, who are mostly mothers, can take advantage of the system and manipulate it and manipulate the judges in order to restrict or minimise contact or deny contact of the children with the non-resident parent. And this is such a powerful manipulation of the process that it's almost impossible for the non-resident parent to actually stop it. And judges are failing, in my mind, to even recognise this is happening, or if they are, they're ignoring it, and are totally failing to get a grip on this issue. And what I find really troubling is that you get the president of the family court division, you get the judges, you get the Ministry of Justice complaining that our courts are being clogged up. Well, of course they're being clogged up, but not by us, the service users, because when the non-resident parent enters into the family court system, it's usually the only last choice they have in order to regain contact with their children. They have nowhere else to go. But the courts are now openly allowing mudslinging, spurious allegations, driving fact findings, which are in themselves clogging up the family court system for months and months on end, with untold damage and harm being caused to the children in the process. The family court system itself is probably one of the most dangerous places on the planet for a man, quite often the man, the non-resident parent, to actually enter. And I just think the audacity of the family court to accuse us, the service users, of clogging up their system, where they are applying a complete lack of common sense in dealing with these issues, which are unfortunate but may be understandable in any relationship up and down the country.
So what do you think are the most significant points of that journey? In other words, what are the real danger points for the non-resident parent who you say are mostly fathers?
Okay, so the most significant parts of the process, which I think people can manipulate, well, I think the vlog makes it very clear that it actually starts before any application is made, where the resident parent stops entire contact with a non-resident parent, and then throws out spurious allegations as a basis of doing that, because that sets the status quo. If you enter into the court system where there is no current contact, then it's very unlikely that the court will then impose contact at an early stage until the allegations are actually heard. And so that in itself is a massive weapon and a manipulation of the family court process, simply by denying contact before a application is even made. And then I think the second significant area is that of the Cafcass safeguarding letter and the safeguarding phone call, which I believe can be very simply manipulated on a 45-minute conversation with the resident parent just doubling down on talking to Cafcass about the fact that they've been abused, manipulated, coercively controlled, just by throwing all the sound bites that they can at the Cafcass officer, who then at the end of it pretty much has very little option but to then recommend to the court that because there is no current contact and these allegations have been made, that direct contact should not be resumed at this point until the allegations have been addressed by the court. So that again sets the status quo of no contact and is driving this agenda of separating the children from the non-resident parent.
And what is the next part of the process that can be manipulated?
Well, the third main area which I see as being manipulated are the first hearings themselves in front of judges or magistrates, where once again the resident parent has to just simply declare that they are victims of abuse and coercive control, and at that point the judges need to, in order to determine whether they have relevance, whether they're appropriate, or whether it would be proportionate to hold a fact-finding hearing, they have to then ask for the full evidence to be presented. And the non-resident parent, who is predominantly the fathers, would then get a chance to respond, but that process itself can take up to 3 months, if not longer, to complete, for the mother to write a statement of allegations and a Scott schedule, and the father to respond before you now come back for, in effect, a case management hearing. And then we have the next step, which is a case management hearing, where judges, in the space of maybe only 45 minutes to an hour, are supposed to apply the practice directions 12J to determine whether there should be a fact-finding hearing or not, based on the allegations presented before them. Now, in my firm opinion, there is no way that within the 45-minute, 1-hour hearing, a judge can appropriately determine whether the allegations should be heard or not, or whether they have relevance. And what's happening is that these are just now getting rubber stamped. The mother has made 8 allegations, the judge may take out 3 of them, and then determine that the rest should go to a fact finding. So the notion of fact findings in my mind are now being completely rubber stamped because we have risk-averse judges who are failing to apply any common sense with the spurious and obviously spurious allegations which are sitting in front of them, where if you put to any reasonable panel of people, they'll look at it and say, do you know what, this is stuff that is unfortunate, we're not condoning it, but it's happening within the relationship, we need to draw a line under this now and just simply move forward. But that's not the approach that the courts are taking. And I believe in doing that, they are in themselves institutionally harming the children by denying contact with the non-resident parent, the fathers, for months and months on end, to the point that half a year, 9 months, a year can go by before any facts can be determined. And of course, within that time, the children themselves can then be further manipulated to now not wanting to see the father.
You also say that the resident parent, in order to manipulate the family court, doesn't even have to have any evidence to support their allegations.
Well, this is the crazy part of the whole system, is that you can actually get to the point of 1 year down the road with the non-resident parent, the father, not having any direct contact with the children based on spurious allegations of hate, with the absence of any evidence whatsoever. We have statements which are just presented on sound bites, we have statements presented in twisted, manipulated incidents which may happen behind closed doors, which aren't backed up with any supporting evidence, any supporting witnesses, or indeed even the person making the allegations reporting that these matters have happened at all to any other person at the time. The absence of any evidence whatsoever can still result in a father not having contact with a child or their children for months and months on end. And I think the damage that is doing is absolutely terrifying.
How frequently do you think that the family court is being manipulated in this way?
How often it's happening? Okay, so I think it's endemic within the system. So roughly speaking, the statistics show that going through the family court, in at least 60% of cases being submitted through the family court, that there are allegations of abuse and coercive control. Now, out of that 60% of those cases where allegations are made, I actually feel, I do this from my gut reaction on the hundreds and hundreds of cases which come across the Mackenzie Friends UK network, and the hundreds of cases that I've dealt with personally, I would say that between 70 and 80% of them are nothing more than spurious allegations that if any reasonable panel of the members of the public would look at and say, yes, they're unfortunate incidents, but they have complete irrelevance to moving forward with charge arrangements. And in terms of fact findings on a common sense basis, should just be struck out and people just move forward, draw a line, get over it, move on. But sadly, that's not what's happening in the family court, where judges, risk averse, are once again just applying 12J totally incorrectly in a complete lack of common sense, and are causing months and months of delays while these spurious matters are being heard at fact findings, and where, quite frankly, the non-resident parent is being thrown under the family court bus with proved spurious allegations based on hate, who are then forever labelled as child abusers or domestic abusers. And in the meantime, the relationship between them and their children are being destroyed. So yeah, I believe this is endemic.
So when I personally watched your vlog, One of the points you had made, which I found particularly troubling, is where you describe the appeals process itself can be used as a weapon against a non-resident parent.
Yeah, look, how mad is this? We have an appeals process which should be in place to protect people, to protect justice. But in the family courts, the appeals process itself can be used as a significant weapon against a non-resident parent. Even the threat of it can be used as a significant weapon. For example, let's take at one of the case management meetings or directions hearings where a judge has to decide whether the allegations meet the standard of going through to a fact finding or not. But on this occasion, we actually get a judge from Planet Common Sense, rare I know, but let's assume that happens, who actually determines that the allegations don't meet the standards of practice directions 12J and should be thrown out at that point, and we just proceed on the normal track through the family court. Well, all the resident parent has to do at that point is to appeal that decision. It doesn't matter at the time whether there's any sufficient grounds to appeal it. The appeal process itself could actually delay matters for another 3 to 6 months. Even if we get to a fact finding, and at a fact finding, a judge determines that there should be no findings of fact that there are no findings of fact against the non-resident parent on the abuse allegations, well, the resident parent could then just appeal that decision and say that the judge has got it wrong and hasn't applied the evidence properly. Now, it doesn't matter whether that appeal is likely to be successful or not. That appeal process itself could again delay the family court and progression of any contact with a non-resident parent for months and months on end. And so the appeals process is in itself a weapon. And then you can also look at it from the other way round. A father, for example, has had some findings of fact made against them, but they feel that that is completely unjust. The worst thing they can do in that situation is perhaps to use the appeal process, because in doing so, they're actually putting a gun to their own head in delaying any potential progression of contact for months and months on end. And so how many fathers are actually accepting a court's judgment that they may be domestic abusers or child abusers, although in their own minds the events are spurious or made up and never happened, but have to just accept that for the greater good of trying to restore contact with their children. You just wonder where the justice lies in this system. And when the appeals process can itself be used as a weapon against the non-resident parent, then you have to conclude that there's very little justice in the system whatsoever.
So what can actually be done about this? You say that any person can manipulate the family court with spurious allegations based on hate. That can result in restricting or denying child contact with a non-resident parent for months on end. How do people defend themselves?
The blueprint of hate is an incredibly powerful weapon in the hands of the resident parent. And of course, this is something that I have no doubt that lawyers in the family court, solicitors and barristers, that they're fully aware of how to manipulate the system, and this is what's happening on a routine basis, which I believe is for nothing more than financial gain in the hands of quite all too often sick lawyers, where the lawyers have absolutely no professional duty of care to any child. I mean, that is completely disgraceful. How these people are allowed to enter into any family court is a complete and utter mystery to me. But what can we do about it? Well, I'm having to dig deep in terms of my experience. I was a critical incident commander in the police which means that I had to think outside the box, think rationally, think logically, and problem solve some pretty challenging and difficult situations. I was also, as a chief inspector, head of a a strategic policy and planning department for a constabulary for 3 years. And again, I had to scrutinise and look at all our strategic plans and policies and understand how processes work. I also spent 2 years working in the Home Office as a project advisor to what was then ACPO and the Police Minister as a project advisor, specialist project advisor. So I'm trying to draw on all those experiences and actually examine this blueprint of hate and actually seeing whether I can come up with a blueprint of light to challenge it, to combat it, and to try and neutralise it. And that's work that I'm doing at the moment, and I do believe that I'm making some really good ground in that, but I have to give it some considerable thought before I can come back and talk about it. It's not far off, but the ideas are there. And once again, it's something that has never been done before, as far as I'm aware, which is actually to pick apart the process of the family court, to challenge it, and then to suggest to people how to stand up against it. So it's a really important bit of work which I'm currently undertaking, and I hope to be speaking to people again on my vlogs about it very soon. There's a couple of other things in the pipeline which are really important, but yeah, it's going to follow as soon as possible.
There will be people now watching this interview who have yet to see your vlog, so where can they see it?
Yes, thank you. If people haven't seen the vlog, which is called Why the Family Court is So Terrifying, the Blueprint of Hate, then they can actually go and watch it right now at www.theblueprintofhate.co.uk.
And how can people contact the Mackenzie Friend UK network or even yourself directly?
Yeah, I'd be really happy if people wanted to contact me, and that would be at www.contactphil.co.uk.
There must be thousands of non-resident parents out there who need your help and who may also want to get behind your national campaign of #LikeNotHate to expose the family court system from the inside in a way that perhaps has never been done before. And I'd like to thank you, Phil, for the great opportunity to interview you today.
Well, thank you, Michelle, for planning this and taking the time out to speak to me and ask me questions today. Thank you very much.
You're welcome.